Not rolling your window all the way down. Got a Maryland carry permit.
Yes, sir.
Grab a firearm, okay?
Why?
Just till I have to run it just to make sure. Okay?
You coming in my vehicle is a violation. You know that, right?
I'm just letting you know I'm running the serial number on the firearm.
What?
Okay?
What for?
Just to make sure it aligns with the permit, okay?
And you think that's legal and lawful?
Yes, sir. You the registered owner of the firearm?
I am. You pulled me up for tent.
Right,
and you write me a ticket for tent.
Correct.
I showed you that I'm legally and lawfully able to do that. You opened my door, which is already a violation.
The fact that you have a firearm in the car and you're doing all of this puts us at ease, okay?
You realize I'm recording you, right?
Can you unlock the door, sir?
Do you hear me?
I cannot hear you because the window's up and it's not out here.
I'm recording you.
So am I.
And you're trying to violate my rights right now.
You're not violating rights, sir.
Yes, you are.
No, it's not.
You have no reason to touch a firearm. He pulled me over for window tint.
Okay.
From behind me, first off. So
he got windows all around, right? Exactly. So
he said front windshield tint.
So there's obviously a lot going on here, and it's clear this is just a 1-minute clip of a much bigger incident. Now, with that being said, there's a lot of people that don't really understand how case law and court precedence works with firearms. Firearm case law is probably one of my most favorite things to teach. I love teaching this to military, law enforcement, armed citizens. I have a course, certified state course that I teach in many different states in regards to this topic. And so it's definitely one of my favorite ones to teach because there is a lot of case law on firearms, as you can imagine, here in the United States of America. So the first thing that we're going to break what we have down numerically. And so the first thing we need to talk about is the traffic stop. So the legality and the basis for any contact is going to be why the initial contact was made. And in this case, it seems like both the officer and the driver are in agreement that the reason for the stop is because of a window tint issue. Now, with that being said, according to the Supreme Court in United States versus Cortez, 1981, all a law enforcement officer needs is reasonable suspicion to stop a motor vehicle. So all they need is reasonable suspicion to stop a motor vehicle. Again, that's United States v. Cortez, 1981. And so that's where we have with the stop. The next thing we need to look at is the efficacy of why the firearm was taken. So the firearm was obviously in plain view for the officer to see. The officer asked about the concealed carry permit. It looks like this is in the state of Maryland, which, if you know anything about Maryland, Maryland is a very gun control heavy state. And so in this regard, you can do a quick look up and you can see that Maryland requires concealed carry permits if you want to conceal carry a firearm, right? So they don't have constitutional carry there. And so as we continue to go on with this, we see that the officer then goes into the vehicle, takes the firearm to conduct business. So the question is, and what the driver seems to be very upset about, and what a lot of people here on social media are upset about, is did the officer do something against the law? So when we look at this, and we look at this, again, numerically, there's a couple things we need to realize. So Terry v. Ohio, 1968, states that once an officer has reasonable suspicion to stop a suspect, the officer may conduct a limited search for weapons if the officer has reasonably believes the defendant may be armed and dangerous. So in this case, the officer had reasonable suspicion with the window tint violation, and then he can clearly see he has more than reasonable suspicion. He has probable cause at this point since he can see the firearm to see the firearm. So according to Terry v. Ohio, the officer would absolutely be within his rights to take that firearm. Now, the next question is, well, it says armed and dangerous. So the question is, can somebody who is lawfully carrying a firearm be dangerous? Well, let's go back to what the Supreme Court case precedents say. So McLaughlin versus United States, 1986, the United States Supreme Court held that an unloaded pistol was considered a dangerous weapon for three following independent sufficient reasons. Okay, so the Supreme Court said there's three independent reasons why an unloaded handgun would be dangerous. The first one is a gun that is an article that is typically characterized as dangerous, the use of which is manufactured and sold as a dangerous one, and the law reasonably may presume that such an article is always dangerous, even though it may not be armed at that particular time or place. Second one, a gun instills fear in the average citizen. As a consequence, it creates an immediate danger that a violent response will ensue. And third, a handgun can be used as a bludgeoning item. So in this case, we clearly see in McLaughlin v. United States, 1986, the Supreme Court held that an unloaded pistol is a dangerous weapon. Again, not my words, the words of the Supreme Court. Then we go up to Michigan versus Long, which is the first case law precedent that says you can frisk a car. So Michigan versus Long, 1983, the United States Supreme Court concluded that roadside encounters are especially hazardous, and and that danger may arise from a possibility of a weapon in an area near the suspect. For that reason, the court found that extending an area of a frisk to a passenger compartment of a car is reasonable when there is reason to believe that there's weapons in the vehicle. So, in Michigan versus Long, the sheer fact that this is a roadside encounter makes it hazardous. And again, the courts, the Supreme Court, again, is stating that a frisk is reasonable when there's reason to believe there's weapons in the vehicle. Well, we know there's weapons in the vehicle because, again, the officer can plainly see it. Then we're going to go down to United States versus Robinson. This is the Fourth Circuit case law that states that being dangerous automatically follows from being armed. The risk of danger is created simply because the person was forcibly stopped that is armed. So the fact that you are armed and forcibly stopped because it's a traffic stop makes that encounter dangerous. Walker versus Lovejoy out of Virginia states whether a person lawfully carries a firearm is inconsequential because the police encounter is forced, right? So the danger justifying a protective frisk arises from the combination of a forced police encounter and the presence of a weapon from not only the legality of the weapon's possession. And then we see furthermore in Walker versus Lovejoy, legal carried weapons are just as dangerous as illegal carried ones, okay? And so that is what the case law states on it. And now let's look at this from a pragmatic standpoint, right? Are firearms dangerous, right? The military says that they are. Law enforcement says that they are. The 5 cardinal safety rules say that they are. CNN says that they are. Deer, elk, and wild boar, especially when hunting season, think they are. Bad guys say they are. Your mom says they are. The Supreme Court says they are. And more importantly, too, regardless of where you are on the issue of gun control, let's make something very clear. Gun right activists, a lot of people that are in favor of people's constitutional rights to bear arms. I would be one of those people, right? The Constitution states that we can carry firearms and that citizens shall have the right to bear arms. And many gun right advocates believe that's because of the fear of tyranny, right? Governmental tyranny. So I guess the question to people that believe in the Constitution and believe in gun rights, are you going to fight tyranny with something that's not dangerous? I know you're not supposed to say that part aloud. I know when we're talking about guns and gun laws, there's certain things that even gun right activists are remiss to say in public. But let's be honest, right? If you believe that firearms are there to protect against tyranny, are you then going to tell me that that object in which you are going to fight tyranny with is not dangerous? Let's call a spade, right? So I believe the evidence is 100% clear here that the officer does have the at least legal right to secure that firearm until his business is completed, and I believe the case law 100% flushes that out. I think that if this officer were to copy and paste everything that we just said here that's in this template, I think that one could reasonably say that he acted intelligently and within the law. With that being said, it's not a practice that I advocate or teach. Obviously, there are let's talk about the totality of circumstances, which can be found pursuant to in accordance with Illinois versus Gates. There are always going to be totalities that we have to account for. Ultimately, though, I don't make a practice of disarming law-abiding citizens. I appreciate that citizens are armed. I appreciate those that do lawfully carry firearms. I believe it is a God-given right. And so for me, it's not a practice that I do because I think that can actually make the scene more unsafe. But we're not talking about what I would do. We're talking about what the law states is permissible. And in this case, it seems like the law is very clear that if an officer wanted to disarm somebody that was a part of a lawful traffic stop because of the sheer fact that they are armed, I think the case law in that would suggest that the officer is acting within the confines of law, of Supreme Court, and other court case precedents.